In my experience, if you're filing bankruptcy, there's one area that everybody fears more than they should, and that's called the 341 Meeting of Creditors. This meeting is often quick, painless, and far less stressful than most people realize. Hi, I'm Liam Pearlman. I'm a consumer bankruptcy attorney. I've been helping people get a financial fresh start for over 30 years. Before we talk about the 341A hearing, I want you to know that reaching out to a bankruptcy lawyer does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are. If you find this video helpful, make sure to like, share, and subscribe, and contact our office if you have any questions. So, what is the 341A hearing in bankruptcy? What does it mean? The 341A Meeting of Creditors is a required step from the Bankruptcy Code in both Chapter 7 and 13. At this meeting, you will meet the bankruptcy trustee who is assigned to your specific case. The trustee's role is to verify your identity, review the bankruptcy paperwork you filed with your attorney, and confirm that the information you filed is accurate, complete, and truthful. Even though it's called a 341A hearing, creditors rarely attend. There is no judge at the 341A hearing. The trustee is appointed and your attorney will be present with you. And it's important to note that all hearings are virtual and conducted by Zoom. If a creditor does appear, the questions are usually limited in scope, and your attorney's role will be to make sure that those questions don't go beyond what is permitted. It's important to understand that creditors are not allowed to harass and intimidate you during the 341A hearing. At the start of the hearing, you should expect to be sworn in under oath, and your attorney will enter what's called an appearance on the record. The trustee is going to confirm your identity with your governmental ID and social security card. Usually this is done prior to the Zoom hearing. The trustee is then going to ask a series of questions about your schedules. These questions are specifically designed to make sure that you have included all your assets, your liabilities, your income information, and you've scheduled all your debts correctly. The important thing to understand is that these questions are not asked in a vacuum. They are typically generated from the schedules and your petition that you reviewed and signed with your attorney. In most cases, your 341A hearing will go no longer than 10 minutes, assuming you prepared for the 341A properly and thoroughly with your lawyer. Although everybody's case is different, many of the questions are the same from case to case. Verification of identity, your verification of assets, understanding whether you listed all your creditors, verifying the value of your real estate and what's owed on real estate. You will likely be asked whether you have transferred property to anybody, whether you're expecting an inheritance, and whether you're involved in litigation that may result in a meaningful recovery to you. If you're filing a Chapter 13, the trustee might ask you questions about your proposed repayment plan, including but not limited to your expenses, the reasonableness of your expenses, and how you calculated those expenses. The most important thing that you can do before your 341A hearing is spend time reviewing the petition that you signed with your attorney to ensure that the schedules are accurate, correct, and that you're not surprised by the trustee's questions. Typically, if the trustee requests additional documents, your lawyer may and should send those prior to the hearing. It's often common that the trustee will request additional documents after the 341 meeting is concluded. If so, your lawyer will supply those to the trustee for their evaluation. In most Chapter 7s, after the 341A hearing, there are no objections in approximately 95% of the cases. Assuming no objection is filed by the trustee or an interested creditor, you can expect your discharge within 60 to 90 days following the 341A hearing. In a Chapter 13, the repayment bankruptcy, it's a little different. The 341A hearing is usually designed to see whether the trustee needs additional information about income and expenses, and whether amendments are necessary prior to your confirmation hearing. Unless the trustee raises a specific objection or requires additional testimony, which is unusual, you generally do not need to attend a second or continued 341A hearing. The 341A hearing sounds overly formal and intimidating, but most of our clients leave the 341A hearing feeling relieved and surprised that it was stress-free. Remember, reaching out to a bankruptcy attorney does not mean you're filing bankruptcy. It means you're getting guidance and options so that you can understand what steps make the most sense for you with your financial distress. I'm Liam Pearlman. I'm a consumer bankruptcy attorney. If you found this video helpful, please make sure to like, subscribe, or share with somebody that you know might benefit who's having financial distress.